the changes to our power of attorney law. Now, the new law came out of some legislation that was known as Act 95 of 2014. The Act changes some of the existing laws with regard to financial powers of attorney. Our legislature took up the cause of changing our power of attorney law in response to a case involving a woman named Teresa Vine. You see, Ms. Vine had suffered a stroke, and shortly thereafter she signed a power of attorney. Her agent named in that document then went on to harm her financially. Although the power of attorney on its face appeared to be very valid, it was later discovered that Ms. Vine didn't know what she was signing and didn't fully appreciate the powers she was giving to her agent. So one of the goals of the new law is to try and curb the number of financial powers of attorney that are signed under rather suspicious circumstances. The law also requires those who are signing these documents to make choices about the powers and the duties that they're granting to their agents. Furthermore, the legislation is intended to protect third parties, like the banks and insurance companies, from liability if they're asked to honor these powers of attorney. Although well-intended, the new legislation makes powers of attorney more complicated and sometimes confusing. More than ever, the stock powers of attorney are going to be proving to be inadequate for a lot of our clients. If they rely on form documents, they risk having a document that won't allow them to properly manage their affairs. Now, most of these changes to the law become effective on January 1st of 2015. They don't apply to most powers of attorney that were signed prior to that date. So, here are some of the changes to the Act. One of the big changes is how powers of attorney are going to be signed from this point forward. First of all, if you have someone that is going to sign on behalf of the principal, it can only be done if the principal is unable to sign and specifically directs another person to sign the document for them. Second of all, the signature or mark of the principal now must be acknowledged before a notary. Most powers of attorney always had a notary if they were notarized in an attorney's office, but it was not required under the law. And last of all powers of attorney must be now witnessed by two individuals, neither of whom is the agent.